Hello, everyone. My name is Gubin Alexander, and I'm an advocate in Ukraine, actively participating in the activities of the Family, Civil, and Inheritance Law Committee of Ukrainian Bar Association. I'm proud to present this Hague Convention 1980 event together with my co-moderator, brilliant Elizabeth Lucas, chair of the Family Law Committee of the International Bar Association, being in charge of the law office of Elizabeth Lucas. First off, I would like to extend my sincere thanks to all of our honorable speakers. We've got today a really astonishing lineup of one of the most outstanding family law practitioners in the field, both from Ukraine and worldwide. I'm also grateful to IBA for their invaluable support and dedication during the preparation of the event. I have a ton of respect for everyone, but without Barbara Connolly's guidance and Carolina Pedrena's extensive net of contacts, this meeting in such impressive gathering would not be possible. My sincere thanks also go to Child Abduction Lawyers Association based in London, UK. The main question of the event actually contains in its title, The War in Ukraine and 1980 Hague Child Abduction Convention, to return or not to return. I urge the audience to use this seldom opportunity and ask their questions. We, together with Elizabeth, will check this. We'll check the meeting chat from time to time, and we'll read them, if any. We will introduce every speaker before their respective speeches in order to save time at the beginning. Without any further delays, I'm passing the word to my co-host, Mrs. Lucas.
Dobry ranuk, and good morning from my office here in the Boston area. I'm just minutes from Harvard and MIT. And as my colleague Alex said, I am the chair of the Family Law Committee of the International Bar Association. And on behalf of the IBA, I welcome you all, and I thank each and every panelist for joining us for this incredibly important topic and this webinar. I'm going to save my other comments for the end of the webinar because I'd like to use this couple of minutes to just read to you the opening of the convention, the opening comments of the convention, because I think it's important for those who are attending the webinar to be familiar with the words and the importance of the convention words as we discuss this topic. So the Convention on the Civil Aspects of International Child Abduction concluded on the October 25th, 1980. The states signatory to the present convention firmly convinced that the interests of children are of paramount importance in matters relating to their custody, desiring to protect children internationally from the harmful effects of their wrongful removal or retention, and to establish procedures to ensure their prompt return to the state of their habitual residence, as well as to secure protection for rights of, access, have resolved to conclude a convention to this effect and have agreed upon the following provisions. I'm not going to read them all. But Article 1 states the objects of the present convention are A, to secure the prompt return of children wrongfully removed to or retained in any contracting state, and B, to ensure that rights of custody and of access under the law of one contracting state are effectively respected in the other contracting state. I think that's super important for us to remember as we discuss today this topic. So I thank you all for coming, and we will now continue with our first speaker.
Definitely. Thank you, Alice. And our first speaker of today's event is Maria Snishko, Chief Executive Officer of the International Law Department of the Ministry of Justice of Ukraine, which is a central authority for the majority of the international treaties of our state, including Abduction Convention. She will provide us with a really interesting insight regarding the main challenges that MJU faces when dealing with the Hague Convention 1980, as well as much needed statistics with regard to the number of return requests to Ukraine filed to CA recently. Пані Марія, вам слово.
Дякую. Good afternoon. I would like to talk about the main challenges for the Ministry of Justice of Ukraine as a central authority for the 1980 Child Abduction Convention during the martial law in Ukraine. First of all, I would like to point that since the beginning of the war in February 2022, the appropriate declaration was made by the Ministry for Foreign Affairs concerning the impossibility to fulfill completely our international obligations on the territory of Ukraine until the sovereignty and our territorial integrity will be
Restored.
Fully, completely state all over the territory of Ukraine. The appropriate declaration is available on the web page of the Hague Conference. The full text you can find. Despite the war, the Ministry of Justice of Ukraine continues to operate the Abduction Convention fully. So we, as it was before the war and after the war started, we operate all four kinds of the applications. So the return applications, both concerning the return of the child from Ukraine abroad and concerning the return of the child to Ukraine from abroad, and two kinds of access applications concerning the child who resides in Ukraine and who resides abroad. Of course, as we all aware, a lot of people, namely women with their children, moved abroad. So this situation, unfortunately, impact on the all these kind of applications we deal with, and on the general situation with the application of the convention in Ukraine. The statistic of the case is as follows. Since February 2022, as a central authority, we received 86 applications on return of this child to Ukraine. From January of this year till the 1st of July, we received 76 return applications. I must say that usually the statistic was a little bit different. We usually receive more return applications as regards return from Ukraine to abroad. Because of the war, the situation crucially has changed. Also, I would like to say that we also mentioned the tendency of increasing of the access applications. For example, during the first half of this year, we forwarded 43 access applications for abroad. The main ground for this is that 1 year period foreseen by Article 12 has elapsed, and many applicants decided to change their first desire and not to submit the return application, but rather to submit the access application. For example, in 2021, we forwarded only 7 access applications. So as you see, the war influences on the general tendencies as regard to the access and return applications. And I should also mention that in 2022, of course, we didn't have too much return applications as regard to return of the child from Ukraine abroad. But from the beginning of this year, the number of the applications a little bit increased, and we have such applications. For example, we have already received 12 return applications on the return of the child from Ukraine abroad. As regard to the geography of the applications, it is clear that it's the European states, the states of the EU, Poland, Germany, but we also have applications from such states as United States of America, Canada, Mexico, Norway, Denmark, different states of the world. As the central authority, the Ministry of Justice of Ukraine informs citizens on a daily basis on the requirements to the documents which are necessary to initiate the proceeding under the Abduction Convention. Nowadays, special attention is drawn to the provisions of Article 12 of the Convention. In particular, we are talking about a one-year period. The position of the central authority of the requested state is that the return application should be forwarded to the competent court before a one-year period has elapsed. I will talk about this period later. Important to solve the issue amicably, including through the mediation, which is in the best interest of the child, and of course on possibility to apply with the access application. As a central authority, we does not forward applications to Russia and Belarus, it's clear, but we provide information on the possibility to apply directly to the court in these states. As regard to the applications, I would like to make several remarks. The list of supported documents confirming the application should include inter alia the authorization under Article 28. We ask the applicants to sign this authorization personally, and the consent to processing the personal data of the applicant and the minors. We elaborated a special form, and also always requires the applicants to sign this form. And also the documents confirming the children's habitual residence in the requesting state. I would like to point that all the documents should be combined with the translation in Ukrainian language when we are talking about the incoming cases, and on the foreign language of the state, of the requested state, when we are talking about the outgoing applications. We always explain and to our applicants about the language requirements and about how they should, in which language the application should be translated. The translation shall be affirmed by the wet seal and the signature of its translator. We accept the documents in electronic form. We ask them to be sent in PDF format and accept the documents via email. Of course, we all understand the decision on return of the child is made by the court. It is clear that the court have different opinions on whether the child has already been settled, as we, for example, talking about the requirement of Article 12. Because in many cases, unfortunately, because of the duration of the stay of the child abroad and duration of the war, that in many cases, more than 1 year has already passed since the date of departure. We all understand that the children usually was removed on the beginning of March of 2022. So when parents, for example, when one of the left behind parent applies to us, for example, even now, we are talking about the situation when the 1 year period of foreseen by Article 12 has already passed. So the foreign courts, in most cases, initiated during the last year, rejected on return under Part 1, B, Article 13 of the Abduction Convention. And under our experience, we see that it is very important to mention in the application on return the date of removal and or retention. So as I mentioned, many central authorities of foreign states consider this 1 year period of time from the date of removal, and usually very formally use this period. So, for example, German Central Authority considers that the case should be submitted to the court before this date. But in many cases, the children were moved abroad with the consent of the left behind parent. But it was at the beginning, and as the rules of the crossing the state border were changed, no notary consent was necessary. So we very often try to explain that in this particular case took place not the wrongful removal, but rather wrongful retention. So it is very important to provide evidences that despite the removal of the child could be considered as not wrongful, but the retention of the child is wrongful, should be considered as wrongful, and the date of the removal and retention are not the same date as the date of the removal is not the same as the date of the retention. Sometimes it is, of course, each case has, in each case, it depends on the situation, and in some cases, it is very difficult to prove this temporary whether the removal and retention has temporary character. Very often, the children is the one of the parents took the child from one state to another state and then to the third state. So it's very important to see the situation, to check the situation and to understand where was the place of habitual residence of the child, when took place the wrongful removal or retention, and whether it was a retention or a wrongful removal, and to determine the date of this starting of this event, and better to use Article 12 and to understand whether the Part 1 of Article B is applicable or Part 2 of Article 12 is applicable. One of the new features of the last year is that we received the application on return of the child from Ukraine to the state to which it was displaced after the beginning of the war. And one of the parents with this child received the temporary protection under EU directive in EU state. And for us, it is quite confusing situation because we all understand that the state of habitual residence of this child should be considered Ukraine, but the left behind parent requires return to the state in which they were, for example, even more than a year, but in each case, it should be considered whether the state becomes the state of habitual residence, whether the child is settled in its new environment, whether Article 12 could be applicable, and other articles of the Abduction Convention. Of course, as I mentioned, we all understand that a 1 year period of time has already elapsed, and this is quite serious argument for the courts to refuse in return of the child. But as I said, in each case should be considered whether the child is settled, whether the new environment is could be considered as a new place of habitual residence for this particular child, or the child is in so-called bubble environment, and this new state not the center of his or her life. For example, we know about such cases when the child even if the child doesn't know language or has some problems with the school attendance, etc., and all the communication of the child is concentrated with the mother, for example, or father, or some relatives, or Ukrainian environment, and so on. As I mentioned, also that foreign courts refused, very often refused, unfortunately, to return the child. And the main argument was the war, of course. The court apply Part 1B, Article 13 of the Abduction Convention. But at the same time, the situation began to change. We already have 3 return decisions, court return decisions. The court in each particular case considers the circumstances and evidences and decide on the merits. For example, recently, as I mentioned, we have 3 return cases. Also, the court approved the amicable agreements of the parents in 6 cases. The applicants withdraw 7 applications, and the court refused the return in 11 cases. So I would like to mention about this amicable agreement. When the court approves such amicable agreement. For example, we have recently we received information that it was enforced the court order on by which it was improved the amicable agreement of the parents, and this amicable agreement actually foreseen that the child should be returned to Ukraine after the end of the war or not later than July 2023. So unfortunately, the war didn't end, but the child, according to this court decision, German court decision on approval of amicable agreement of the parents, returned in July to Ukraine. We believe that it is important that our ministry informs constantly the central authority about the situation in Ukraine. We always refer to the order of the Ministry of Reintegration of Temporary Occupied Territories of Ukraine, which determine these territories which are warfare or were conducted or which are under temporary occupation. And we believe that the central authorities and the courts abroad, they consider each particular case and arguments of the parties and the evidences, and also took into account our information on the case. Some remarks concerning the incoming cases. I would just like to remind that as a central authority, we conduct all measures which are foreseen by the order of operation of the convention in Ukraine. But in case the applicant has a lawyer or the state of origin of the applicant made reservation under Article 26 and 42 of the convention, and on the principle of reciprocity, we do not represent the interests of such applicants in the court. I would like only just to remind this information. Maybe this is all information I would like to point on Article 9 on Convention on Abduction Convention. I would like to mention about 1996 Protection Convention, only a few words for your attention. I just would like to point that from the 1st of January of this year, Ministry of Justice of Ukraine is no longer a central authority for this convention. The National Social Service of Ukraine is the central authority for the convention. We consider this convention is very important during this situation we have, and taking into account the fact that a lot of children are abroad now, including the children in difficult life circumstances, orphans, children placed in the child care protection institutions and family type advantage, etc., etc. Before the 1st of January, we dealt also with the applications under this convention, and provided assistance to the competent child protection authorities as in Ukraine and also abroad. And in this regard, I would like to point that very often parents or
Пані Марія, я перепрошую, у нас таймінг. Я буду дуже вдячний, якщо ви вже зможете передати слово наступному спікеру і буквально
only a few words regarding this convention. I would like to say that our parents, custodials, they need a very often assistance abroad of the lawyers as regard to the confirmation of their power or deciding different issues regarding the representation of their interests in the child protection institution of the state. The state where they are now. This is the main general remarks concerning our challenges during this period of time. I hope this information will be useful. We are open for the communication, and in case you have questions, you can send them to our emails and communicate and to discuss particular case and particular documents, etc. Thank you for your attention.
Yes, thank you very much, Pani Maria, for your very interesting speech, and it was very detailed, and it contains definitely very important points, and it was really valuable. Thank you very much. Our next speaker is Olga Stupak, Judge of the Cassation Civil Court of the Supreme Court. She has a real interest in the Hague Children's Conventions and is one of the main driving forces in Ukraine pushing towards their duly application in our jurisdiction. Ольга Вячеславівна, прошу до слова.
Доброго дня, колеги. В першу чергу хочу подякувати організаторам за те, що сьогодні всіх зібрали. Ви бачите, навіть тривоги не лунають, дякувати Богу, так як вчора у нас був важкий день в Україні. Дякую нашим іноземним друзям, в першу чергу, за вашу моральну підтримку Україні і не тільки. З огляду на те, що часу мало для виступу, я коротко розкажу про ті основні проблеми, з якими ми прогнозуємо, що будуть стикатись національні суди, оскільки, застосовуючи Гаазьку конвенцію про запобігання міжнародному викраденню дітей, в мирний час українські суди розглядали переважно справи про повернення дітей, які перебувають в Україні, і повернення їх в інші країни іноземні як місце постійного проживання. Трішки статистики для ілюстрації. Спочатку роботи Верховного суду, який є у нас судом третьої інстанції, всього близько 60 справ цієї категорії було розглянуто касаційним цивільним судом у складі Верховного суду. Вже в воєнні роки, 22-й рік, лише 7 таких справ розглянув касаційний цивільний суд, і у цьому році, 23-му, не дивлячись на те, що вже більше половини року сплинуло, лише 1 таку справу розглянув касаційний цивільний суд. І підхід був зрозумілий. Але от вирішуючи одну із справ ще у 21-му році, я зараз спробую розгорнути презентацію. Так, хвилиночку, щоб щось я, як завжди, поспішила і Так, бачите вже. Вона в мене така велика, ну, щоб учасники змогли ознайомитись потім з нею. Але на прикладі однієї із справ, яку ми розглядали, хоча й в 22-му році, але ви бачите, справа була ініційована в 19-му ще році, тобто до війни, ми стикнулися з нетиповою ситуацією, коли заявник, батько, українець, звернувся з заявою про повернення дітей за Гаазькою конвенцією саме в Національний суд України, в той час, як діти перебували за кордоном. За обставинами справи він свого часу своїй дружині надав дозвіл на тимчасову поїздку мами з дітьми на той час ще до Російської Федерації для того, щоб відвідати родичів. Але звертаю вашу увагу, такий дозвіл був тимчасовим. Мама поїхала і з закінченням строку цього дозвілу не повернулась в Україну і не повернула дітей. Більше того, вона з території Російської Федерації перемістилась в третю країну, на думку батька, це у Вірменію. І звернувшись до українського суду з такою заявою про повернення дітей з-за кордону за правилами Гаазької конвенції 80-го року, на жаль, суди першої апеляційної інстанції відмовили заявнику в задоволенні позову з посиланням на те, що він звернувся, по суті, не до того суду, тобто не до суду тієї країни, де сьогодні перебувають діти. Ми провели багато часу в дискусіях серед своїх колег, і це перша справа на сьогодні, ви бачите, в якій Верховний суд скористався процедурою запиту до Постійного бюро Гаазької конвенції з міжнародного приватного права. Для того, щоб отримати якісь роз'яснення по застосуванню і співвідношенню застосування Конвенції 80-го року і Конвенції 1996 року про юрисдикцію, вам відомо, що застосовуються при визнанні, виконанні та співробітництві щодо батьківської відповідальності та заходів захисту дітей. І, по суті, ось ця справа, в ній детально розписаний алгоритм і для національних судів, і мені цікаво буде почути думку наших міжнародних колег, чи так само вони розуміють це поєднання застосування правил двох конвенцій в питанні визначення юрисдикції такого спору, тобто суд якої держави є компетентним вирішити заяву заявника про повернення дітей. І в цій справі ми сформулювали висновки з урахуванням рекомендацій і роз'яснень, наданих Постійним бюро Гаазької конференції, про те, що тут в мене інші є деталі, але я зупинюсь якраз на питанні визначення юрисдикції, про те, що обидві конвенції є доповненням одна одної. І не перешкоджають застосовувати правила Конвенції 80-го року при визначенні юрисдикції, цьому не перешкоджають правила Конвенції 1996 року. І, по суті, висновок ми зробили такий, що заявник може звернутись не тільки до суду, ну я тут не буду, щоб довго повторюватись, а і до компетентного органу договірної держави, як в країні місця постійного проживання дітей, якщо цей суд, ця країна ще зберігає за собою юрисдикцію, так і до компетентного органу чи суду країни перебування дітей на момент подання такої заяви. І для цього на одному із слайдів, ви бачите, я його зараз демонструю на екрані, Верховний суд, застосовуючи правила цих двох конвенцій у їх співвідношенні, сформулював висновок про те, якраз, що і національні суди України зберігають компетенцію для вирішення таких заяв про повернення дітей за Гаазькою конвенцією 80-го року, року, якщо в іншій країні теперішнього перебування для діти не набули місця постійного проживання чи звичайного перебування. І якщо підсумувати всі висновки, до чого зводиться рішення у цій справі Верховного суду, то ви бачите, я так зробила схематично, про те, що куди може звернутись заявник з відповідною заявою. Перше, це органи країни звичайного місця проживання дитини або країни фактичного перебування. І відповідно і в першій країні, і в іншій країні це можуть бути національні органи, але якщо звернення відбувається через відповідний компетентний національний орган, ну у нас це Міністерство юстиції, то цей орган звертається до компетентного органу країни перебування дитини і у разі недосягнення згоди мирним врегулюванням національний орган договірної держави, де фактично перебуває дитина, вже там в суді ініціює цей спір. Так само в країні звичайного місця проживання може заявник і звернутися до національного суду, що по суті відбулось от в цій справі, про яку я вам розповідаю. Але в цій ситуації заявники, відповідно юристи, які супроводжують ці справи, повинні розуміти, що отримання рішення національного суду буде передбачати проходження процедури в країні фактичного перебування дитини, такої процедури, як визнання і надання дозволу на виконання. І, відповідно, бачите, тут у мене цими стрілочками це позначено. Так само, якщо звернення відбувається в країні фактичного перебування, чи то в національний орган, чи то в суд, якщо суд іноземної держави постановить відповідне рішення і потрібно буде його виконувати на території України, так само потрібно буде пройти процедуру в Національному суді України. Ось це схематично, до чого зводяться висновки в цій справі, але ключовим моментом для визначення юрисдикції є визначення країни постійного місця проживання до моменту незаконного переміщення дитини. І саме тут ми, як Верховний суд, бачимо недоліки в роботі наших судів першої апеляційної інстанції, оскільки не вдаються до детального встановлення обставин справи суди, їх аналізу, для того, щоб встановити, а яка ж країна була місцем постійного чи звичайного проживання дитини до моменту незаконного переміщення. Які нові правові проблеми принесла нам війна? Дотично про них вже говорила Марія, і я думаю, що це буде така група питань, яку доведеться вирішувати правникам, не тільки українським, а і нашим міжнародним колегам. Це про те, чи можна оцінювати як незаконне переміщення дитини факт виїзду дітей за кордон на початку повномасштабного вторгнення країни-агресора на територію України у лютому 2022 року. Ми з вами знаємо, що у нас порядок перетину державного кордону для громадян України, який був чинним і на 24 лютого 2022 року, передбачав, що неповнолітня дитина може виїхати у супроводі там або одного з батьків, або не обов'язково батьків, але обов'язково за нотаріальної згоди батьків. І ми знаємо, що 24 лютого 2022 року, по суті, без внесення відповідних змін в нормативні документи і порядок перетину державного кордону, Державна прикордонна служба України фактично відкрила кордони, і діти виїжджали в супроводі, от з ким могли, з тим і їхали. І тільки у березні 22-го року, а точніше 3 березня, були внесені зміни в цей порядок перетину державного кордону, і де зазначено, що дитина, яка не досягла 16 років, може перетинати кордон у супроводі одного з батьків, бабусі, дідуся, там сестри, брата повнолітніх або іншої сторонньої людини за письмовою згоди одного з батьків. Тобто, не дивлячись на те, що ось такі зміни були внесені, ну, ми детально ситуацію не аналізували, тому що не було якраз таких справ, але я думаю, що продовжувався дотримуватися Державною прикордонною службою той підхід, що діти виїжджали от з ким в них була нагода. І знову ж таки ще одні зміни вже воєнного часу у квітні 22-го року були внесені, які підтвердили можливість виїзду дитини за кордон у супроводі, але окреслено, що це в період дії воєнного стану. Тому одне з ключових правових питань, яке постане, на сьогодні ще, на жаль, судова практика національних судів на нього не дала відповіді, чи можна отакий виїзд дитини після початку повномасштабного вторгнення країни-агресора кваліфікувати як незаконне переміщення кордону. Так само, чи можна говорити про те, що якщо на той час була мовчазна згода, наприклад, одного з батьків і дитина з кимось виїхала, а потім, коли вже сьогодні зі сплином більше ніж року після початку війни, там інший з батьків передумав, умовно кажучи, і може заперечувати перебування дитини за кордоном і вимагати і просити дитину сюди повернути. Тобто, коли от почнеться цей період незгоди чи період так само незаконного вже перебування за кордоном. Це ті правові питання, які нам в майбутньому доведеться національній судовій системі вирішувати. На сьогодні більшість справ, які доводиться розглядати судам національним, пов'язаним з захистом прав дітей, які знаходяться за кордоном, це спори про встановлення способів участі у вихованні дитини та спілкуванні з дитиною того з батьків, хто залишився в Україні в той час, як дитина перебуває за кордоном. І, безумовно, судова практика в зв'язку з цими подіями зазнала докорінних змін. Ми почали встановлювати, ми це суди, такі способи участі, як зобов'язання того з батьків, хто перебуває з дитиною за кордоном, забезпечити спілкування засобами мобільного зв'язку, інтернет-зв'язку з тим з батьків, хто перебуває в Україні. Продовжуються спори стосовно визначення місця проживання дітей, в тому числі і в той час, коли дитина перебуває за кордоном. Так само судами національними застосовуються заходи забезпечення позовів у таких категоріях справ, наприклад, і в тому числі зобов'язати іншому з батьків, хто перебуває з дитиною за кордоном, надавати можливість телефонного зв'язку там з іншим з батьків. От така на сьогодні ситуація, з якою працюють національні суди, але підсумовуючи, можу сказати одне. Я думаю, що після ось такого висновку Верховного суду ми прогнозовано можемо очікувати появу більшої кількості справ саме в українських національних судах про повернення дітей, які зараз перебувають за кордоном. Да, потім залишиться прогнозована частина процедурного питання визнання і виконання цих рішень за кордоном, але я думаю, що це так само реальний шлях врегулювання таких спорів. І в тому числі на сьогодні національні суди готові і продовжувати розглядати заяви про визнання і виконання рішень іноземних судів, так само, якщо буде стояти питання про повернення чи з України кудись дитини, чи в Україну. Але, будучи реалістами, я думаю, що ми всі сьогодні розуміємо, і тут для мене важлива думка наших міжнародних колег, сьогодні в Україні розуміння є таке, що немає жодного безпечного місця на території України для того, щоб повернути зараз під час війни дитину в Україну. І це, по суті, складає ті підстави, передбачені пунктом Б частини 1 статті 13 конвенції. І тому тут важливо нам почути вашу думку, шановні колеги. Чи так само ви розумієте? Можливо, тут у нас ми якісь дуже сильні бачимо перестороги в цьому питанні, чи все ж таки, який ваш погляд з цієї сторони? Дуже дякую за наданий час, готова відповісти на питання.
Так, дуже дякуємо, Ольга Вячеславівна, за вашу доповідь. So, we have next speaker. Yes, Alice.
Thank you. I had to go back to the English. You said to me, right, Alex? Okay. Thank you. That was very interesting, and certainly understanding what's actually happening on the ground in Ukraine is so important for the rest of us who aren't there and understanding what's happening, but we only see it necessarily on the news or hear about it. But we do have practitioners here who are working in countries on cases that involve Ukrainian children. So now we're going to turn to the issue of mediation of cases involving the return of children to Ukraine. And I'm going to introduce Alison Shalaby, who's the CEO of Reunite. She started in 1991 as a volunteer and has been the CEO since 2010. Reunite is a leading NGO specializing in the international movement of children. They have a variety of things that they do regarding the international movement of children. They have an advice line. They've developed preventative initiatives. They raise awareness and research. They engage foreign governments. And what we're going to talk about now is they also promote mediated solutions regarding the movement of children. And so without further ado, I introduce Alison Shalaby. Thank you.
Thank you. Thank you very much for the kind introduction, and it's a pleasure to be here, so thank you for inviting me. I think if we're going to talk about mediation in these cases, we would certainly look at it in the context of the cases that we're seeing through our advice line. So our advice line, telephone advice line, is open to parents anywhere in the world of any nationality. And in the last year, we have actually been seeing Ukrainian parents from Ukraine contacting the advice line to explain that their children have been either wrongfully removed from Ukraine or wrongfully retained outside of Ukraine. So at the moment, we have ongoing cases of abduction, retention from Ukraine to Canada, to Jersey, to Germany, to Egypt, to Poland, clearly to England and Wales. And then going the other way, we have abductions from Croatia into Ukraine, from England and Wales into Ukraine. And we speak with both the left behind parent and also the abducting or retaining parent. So we see it from both sides of the coin, as it were. And there is a real sense that parents are using the war as an opportunity to get the children into a country where they actually have always wanted those children to be, and where they've never had that opportunity before. The other thing that we are seeing, sadly, is that left behind parents are being told by solicitors that a return to the Ukraine is very unlikely due to the situation in Ukraine, which isn't necessarily the case. And it's going to be very interesting to hear going forward some of the case law in these cases with Ukraine, because I'm hoping to hear about really strong case law that children are being returned. And I think that message has to get out to parents involved in these cases, because parents whose children have been abducted from Ukraine are giving up hope, or they may be changing the position that they really want simply based on incorrect information that they are being given. So I think it's a priority, certainly for the legal profession, to share any findings with other solicitors so that parents are actually given correct information. What we're also seeing is cases of abduction into Ukraine prior to the war. We're seeing a lot of voluntary returns of those children, both voluntary returns of the children back to England or back to other countries to get the children out of the desperate situation that is happening over there now. But when we look at mediation, I think one of the things that is particularly hindering any form of negotiation in these Ukrainian cases is this total belief that no judge will return a child to Ukraine while the war is going on. And so, of course, for the abducting or retaining parent, they don't believe that they have to move on their position at all, because they feel that ultimately, whatever happens, if it goes to court, no judge is going to make that decision to return their children. So we have mediated in a handful of cases where either the originating country or the final country is Ukraine, because we mediate in and outgoing cases. And I think it comes down to, what is your definition of a successful mediation? Is a successful mediation that parents absolutely reach an agreement on where these children are going to live? Or is a successful mediation is it that after so many months of the parents not talking, they're actually now communicating, they are thinking about both scenarios? Should the children return? Should the children remain? They're discussing all sorts of aspects of those scenarios, but they can't actually reach a decision on which country the children live with. So whilst we are mediating, we're seeing very few actual agreements. It is being left to the court. Unfortunately, with some of these cases, there is a huge time delay going through the Hague proceedings, which isn't helpful to anybody. But really, mediation can be used in these cases without a war, because it's down to the parents. It's a voluntary process. It's about parents being willing to come to the table and discuss things. Most mediations these days, certainly our mediations, are undertaken remotely through Zoom. Because of the pandemic, most parents, the same as most businesses, the same as most of us being here, we are very used now to things being done remotely. And even though we try and encourage parents to travel, to have face-to-face mediation, they're giving the same answer as everybody else in every other aspect of life. Well, why do we have to travel? We have Zoom. You know, it's good enough to be able to mediate and talk via Zoom. So that is a very quick, brief sort of tour of what we're seeing through our advice line. And the mediation. Our biggest concern, though, is that parents whose children have been removed from Ukraine are being given incorrect information. And that's something that really I would hope that we would be able to address, to give Ukrainian parents hope that, yes, their children may return home. I know that we are overrun quite significantly so far. So I will leave it at that. Quite happy to take any questions or discuss anything further, but I'll keep my intervention at the moment brief. Thank you very much.
So, Alison, thank you so much. I have a question. Just in your experience, I do mediation in my practice as well, and I do find that the Zoom mediation is not as effective. I think I like the phrase that Michelle Obama used, it's hard to hate up close. And when you can get two people in a room across a table, A lot more work can be done. Do you find more success in the face-to-face mediation than you do in Zoom mediation, or in your experience, in your cases, is it equal, or what are you finding?
It's equal. And even prior to the pandemic, we were so used to mediating remotely anyway, because of course you've always got two parents in different countries. And we're very fortunate in the UK that our legal aid will actually pay for the overseas parent to travel to the UK to mediate face-to-face. And we would be offering this to all parents. We'll pay for your flights, we'll pay for your hotels, we'll pay for your train fare. Please come and mediate face-to-face, because we prefer it face-to-face. I think it's easier to control and manage all the emotions when you're face-to-face. But I don't think it makes any difference to the outcome. I think the only thing that makes a difference to the outcome is the parents themselves and their actual willingness and desire to want to reach an agreement. I think very often we talk about parents come to mediation to talk about the best interests of their children. And I think in the abduction cases, they don't. They come with their own needs and wants. And if those needs and wants are met, then they are very willing to make an agreement. But if their needs and wants aren't met, then they don't. So I don't believe that remote or face-to-face makes a difference. I think it's just down to the parents. It's the parents that make the difference.
Thank you so much. Anybody have any other questions for her at this time? I'm sure there'll be questions at the end, and I have a dozen questions, but I also know we have a time limit. So thank you so much, Allison. Our next speaker, who's going to speak on recent case law, is someone quite familiar to me. Because, full disclosure, he is the Senior Vice Chair of the Family Law Committee of the International Bar Association. And his name is Attorney Stephen Cullen. He's also the Principal and Head of Family Law and Private Client Group at Miles and Stockbridge PC in Washington, D.C. And he's going to speak with us about recent case law. So without further ado, Attorney Cullen.
Good morning, Ukraine. I feel like it's the Eurovision Song Contest here, and the Kalush Orchestra is in the background. I'm going to be very brief. I want to, being Scottish, want to get us back on our timetable. That's a very Scottish phenomenon. I know someone else will probably say that too from Scotland in a minute. So I'm going to abbreviate what I have to say, and let me just go through my program for you. Hold on. Okay, so there are an enormous number of Hague cases in the United States, and part of the reason for that is there are so many international families in America, including this guy here, Prince Harry. Obviously, he's now living here, but we have an enormous number of international families. One thing I want to just mention very briefly is, although the talk today is about The Hague, don't forget in America, we have other options. We have a state statute that is able to register and enforce foreign orders. And we have immigration law that can also deal with these issues in a slightly different way. So in America, what do we have? We have obviously the treaty, and then we have an enabling statute in the United States. Then we have the state statute, and then we have immigration law. Now, if we get to the Hague Convention, what you heard Elise say at the beginning is that we have several very important policies behind it. Up until recently in America, the view was that the most important part of the treaty was to return children as soon as possible mollified by recent case law, and there's more recognition now that the whole purpose of the treaty, the welfare of children, also has to be balanced in talking about. We're talking about grave risk to a child, physical or psychological harm, intolerable situation. In America, under our enabling statute, if the taking parent is trying to advance that defense, they have to do it by the clear and convincing evidence standard, which is a higher standard than what is usually used in civil litigation. Normally, it's a preponderance of the evidence standard. So it is a very high bar. In passing, I just want to mention that there have been numerous attempts in America in cases also to advance Article 20, the human rights violation. I see two of my friends, Richard Min and Melissa Kaczynski, are watching this today. They may know this better than me, but I believe it's never been successfully advanced. It's been talked about in several cases. There may be one case where it has been advanced in state court, but I do not know of any federal cases that's ever accepted in Article 20. So we have grave risk. Now, what happens with grave risk in the context of war? So there are a couple of old cases, and this case, Fryer here, was addressing unrest in Israel in 1996. And the unrest was very close to where the family home was. And what Fryer said was, if you're talking about returning children to a zone of war or to a famine or disease, then that may be a situation where a return is not permitted. But in Fryer, the return was permitted anyway. Now, what's very interesting, if we look back over COVID from 2021 into 2022, there were numerous attempts by taking parents to say, well, obviously, you cannot return children to, say, northern Italy, where the situation was particularly bad at the beginning of COVID, or to other countries which were going through particularly bad stages of COVID. My experience was that was rejected outright by almost all the courts that dealt with that position. And it's an analysis that I think you could be making with a return to Ukraine. I mean, we were talking about the worst pandemic in any of our lifetimes, and time and again, the federal courts returned children over and above the pandemic and ignored the disease situation that existed for over 2 years. So there was another famous case, or infamous case, called Silverman in 2003, where the trial court did decide that Israel was a war zone and did not return to Israel. And that was overruled by the appeal court. The appeal court said a general regional violence and suicide bombers does not amount to a war zone, and ordered the return to Israel. Now, what have people been using in cases involving alleged war zones? Well, typically people go to the State Department travel warnings, and over the years, people have tried to use the travel warnings involving Venezuela and El Salvador, and very early on, Northern Ireland, when there were some particularly terrible bombings in Omagh in Northern Ireland, as reasons not to return to those countries. By and large, those were not accepted, or those positions were used by mature children as their basis for saying they didn't want to go back to their requesting country. So, are there any Ukraine cases? Well, it's interesting. There are 4 that I could find, but you'll see the dates of these: 2010, 2011, 2017, and 2018. Although the war in the East had obviously begun, in all 4 of these cases, including the 2018 case, all the children were returned to Ukraine. in some cases over and above the objection of a mature child. So the situation in America is very fluid right now. It seems to me that one would use the pandemic as an analysis as to why returns should still happen. And with that, keeping in mind the time we're on, I'm going to stop there, and glory to Ukraine.
Dear Alice, you are mute.
You would think it was my first time on Zoom, Alex. It's my first time. Thank you so much, Stephen. We appreciate that update on the case law. Our next speaker is also here in the US. His name is Preston Finlay, and he is legal counsel to the National Center for Missing and Exploited Children, affectionately known as NCMEC. He provides legal and technical assistance and training regarding international and domestic abductions. He's also edited and co-authored NCMEC's litigation guide for attorneys handling cases under the Hague Child Abduction Convention. And we welcome Preston.
Thank you very much, and thank you everyone for having me. I will also keep my remarks fairly brief and just share, the experience of our center. We are a non-governmental and nonprofit organization that assists parents and families, and we receive reports of family abductions from across the country and children who are also taken across borders. Most of our experience with international cases, and when I say experience, I'm referring to about 7,000 or 8,000 total cases in our organization's history, and a current active total of approximately 500 active international abductions. Most of that experience we have are with children who've been removed from the United States and taken to another country. This includes approximately 30 children who were removed from the United States and taken to the Ukraine. And among those cases, we have 3 children who are still currently actively missing. In each of the active cases we have to the country of Ukraine, it is believed, although not confirmed, that each of those taking parents, one father and one mother, each have now removed the children further to a third country. Although, again, information is a bit sparse, and their location in at least one of those cases hasn't been confirmed. Our experience with recovered or resolved cases to the Ukraine indicates a similar trend that we see with other countries, and that trend has remained consistent, although again we have a very limited experience with post-war cases in the Ukraine. The largest category, and by far the most common reason that U.S. children are recovered when taken to the Ukraine, is through a mediation or through a voluntary resolution. It is not always a formal legal mediation with both parties represented by counsel. Sometimes it is an informal negotiation or discussion among the parents, or a voluntary return on the part of the taking parent. That right now constitutes 32% of our recovered or resolved cases from the Ukraine. The next highest category are Hague returns itself. We have seen Ukraine courts return a significant number of children to the United States, and is something that we hope will continue. And I'm pleased to hear from the judge earlier, who's looking to continue that record, which I think is commendable, and is comparable or in some ways a little bit higher than we've seen in other countries in the region or across the continent. Sadly, this still leaves quite a few cases that are resolved outside of the courts or outside of an amicable resolution. There is approximately 10% of the children taken to the Ukraine were only recovered when their searching parent decided to go and re-abduct those children. We sometimes refer to that as a self-help return, because it does not always involve a forcible taking or a forcible abduction, but that is still reflects a parent who feels that there are no other options and there is no legal recourse to recover their child, so they have to act outside of the system. And then a small portion of our cases involved children who were recovered by a law enforcement agency when the taking parent maybe traveled, crossed a border, or were picked up through Interpol notices or arrest warrants for them, as international child abduction remains a crime in the United States under both federal and state law. And sadly, 28% of all children that our center has been involved with who were taken to the Ukraine were never recovered at all. Contact was lost, or the searching parent was never able to obtain either a return or any meaningful access to their child in that country. Each of these results and resolutions indicate some of the practical hurdles that parents face, and that we hear time and time again from U.S. families who are impacted by this issue. The hurdles they face involve first finding and locating their child, which can be increasingly difficult if the authorities are unable to help the parent with locating. The enormous costs and expense and time and energy that is required to search for their child, to obtain legal help, and to travel to recover their child, and the emotional burden of reunification with their child. Each of these are areas where our center has tried to support families. We have a travel program grant to try and send families abroad to pay for the costs of their flights and travel. We have trained counselors and mental health staff who can help a family prepare for the connection with their child and prepare for reunification so that it occurs in a way that is not traumatic to the child. And of course, our center is happy to work with law enforcement agencies or others to help locate children wherever they are around the world. So my suggestions and recommendations from our center's experience are to continue to emphasize the treaty and the court process as the most meaningful and beneficial way to resolve a case, and the method that utilizing the courts and the treaty are likely to be the least traumatic for a child, and also to lead to the most permanent resolution to the case. It's less likely for a re-abduction or a secondary abduction to occur if the parties feel like they are being heard and that their outcome was adjudicated fairly by the court system. So with each of those experiences, I would be happy to fill in more details. But again, I would just encourage everyone here, and I'm personally encouraged by your focus on trying to maintain access to the courts and maintain access to reasonable decisions for returning children. So thank you again.
Thank you so much, Preston. And now I'll turn it over to Alex.
Yes, thank you, Alice, and thank you, Stephen, thank you, Preston, for very interesting and important insight into U.S. jurisdiction. And Mr. Richard Mean has kindly informed everybody that actually there was one case under Article 20 in the U.S. jurisdiction. So thank you, Mr. Mean, for this information. I'm glad to give a floor to the colleague from Canada, Mrs. Farah Hudani, a partner at Barris & Hudani Doris LLP. She represents Canada today and provides us with a valuable insight on the return of the relocated children to Ukraine upon the convention. Please, Farah.
Thank you so much, Alexander. I appreciate that. So I did look at recent cases in Canada on returns to Ukraine, and there aren't any specific reported decisions in the last 10 years. Certainly there are cases where a child has been removed from Canada to the Ukraine, and Alex and I are working on a couple of those right now. But I thought I would spend my time today instead explaining how Canada treats the issue of war under Article 13B of the Convention based upon the Canadian cases. As everyone knows, Article 13B speaks to the discretionary defense of grave risk if the child were returned, which would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. According to the Supreme Court of Canada decision in Thompson, the standard for grave risk is that the risk must be grave, weighty, substantial, not trivial, and severe, and the harm must amount to an intolerable situation. And Canada is quite stringent on the Article 13 defenses, and Thompson continues to apply. So for anyone who has some familiarity with Canadian cases. There is a more recent Supreme Court of Canada decision called Balev, but Balev didn't actually have anything to do with the risk of harm threshold. It had to do with the habitual residence threshold. So Thompson still continues to apply in terms of the risk of harm threshold. It's very high, it's very stringent. In terms of war, Canadian courts actually often cite the US Court of Appeal decision in Friedrich for clarifying that grave risk of harm for purposes of the Hague Convention can exist when the return of a child puts the child in imminent danger prior to the resolution of a custody dispute, and that imminent danger can include war, famine, or disease. But based upon my review of cases in Canada dealing with war, specifically under Article 13B, the conclusions, I'll talk about the conclusions or the ratios that can be drawn from those cases, and then I'll kind of go into the cases. There's 3 or 4 that I think are somewhat important to know from a Canadian law perspective. So the ratios really, or the conclusions that can be drawn from these cases are that Canadian courts have found that moving to a country with war, but not in a direct active war zone, is insufficient to meet the grave risk of harm test. Okay, so that's one conclusion that can be drawn from the cases. The second conclusion that I think can be drawn from the cases that deal with this issue are that the severity of the harm of the situation may be met, but the risk of harm can still be insufficient to rise to the level of the Article 13B defense. So the risk of harm can be mitigated by factors such as the child having previously been to the country in the current or similar conditions and returning without issue, or a lack of evidence that the parent would intentionally put the child in a situation that would place the child's life in jeopardy. Okay, so it's really about constructing the case in that manner, like putting together the affidavit evidence and the expert evidence on those issues. I'll discuss it a little bit more, but as I think it was Alison Shalabi pointed out, I think it's important for people to know and practitioners to know that it is not, you cannot just say there's a war in Ukraine and expect the court to take judicial notice and not order the return. That is not the way the Canadian courts are looking at this for sure. The onus is still on the party wrongfully retaining the child to show on a balance of probabilities that the child would be exposed to harm or otherwise place the child in an intolerable situation if returned. So in terms of the cases, the Alberta Court of Appeal, and I can put in the sites in the chat function. I can put in the case sites to the extent that anyone wants those. I can do that or send an email around. But the Alberta Court of Appeal in Brill, that's 2010 Alberta Court of Appeal, dismissed an appeal from a decision where a judge had ruled that despite the higher probability of war or terrorist activities in Israel, the child's daily safety was not a significant risk and the child was ordered returned. Okay. JS versus RM is another case in 2012, also Alberta. And in that case, they relied on the Brill decision. And now the challenge with JS was, although the court found, the court did not find that the war or terrorist activity would impact the child's daily safety, and they didn't find that to be a significant risk. And in that case, the other country was East Jerusalem. And the child was of Arab Palestinian descent, and the mother was arguing that because of the Palestinian-Israeli tensions over the land in East Jerusalem, that the child should not be returned. And the court didn't find that the risk to the child's daily safety was sufficient to meet the Article 13B test, but because the child was mature and able to express their own objections, they didn't order the return. But it didn't have to do with the war in and of itself. It was the other component of the Article 13B risk, which was the objection of the mature child. So the next one is GB versus VM. It's an Ontario case. And in that case, joint custody was granted by a court in Hungary in 2005. The mother removes the child to Ontario in 2011. The child was of Roma heritage, and the mother was a well-known Roma human rights activist. The father applied under Article 12 of the Hague Convention for the return of the child. The application was granted. The mother submitted that the child was at risk of danger because of threats of persecution received by activities and the child's Roma heritage and persecution of Roma people by the Hungarian groups. That's what she argued. The court found that conditions in a country that may be more unsettled and pose a greater risk to its residents than conditions in Canada is not sufficient to establish the Article 13B risk of harm. There wasn't enough evidence of the active risk because the child had lived in Hungary for years without issue. The last case that I want to talk about is Vieira versus Dos Santos Trillo, which is a case in another Alberta case. The court cited the Alberta case, and this was a case where the mother submitted several reasons for not returning to a child to Brazil, including that the child was at risk to being kidnapped. Brazil was in a violent situation at the time. It would be harmful to return the child to Brazil. And still, again, even in that case, the mother had adduced evidence from experts. She tried to adduce all kinds of news articles, and still the child was returned to Brazil again for the same reasons, because there was no demonstration that the child's daily activity would be at risk of harm. So I think a Canadian court may think differently if a child were to be returned to an active war zone, but it's not sufficient to just say, okay, Canada, take judicial notice of the war in Ukraine. Okay, it depends on what side of the argument you're facing, but in either case, I think if you're on for the parent that's seeking the return to the Ukraine, you need to get expert evidence. You need to get affidavit evidence. You need to show how the parent is going to demonstrate that the area that the child is in is still safe, or what precautionary measures that you're going to take. But Canada is certainly not going to just not return children because there's a war in Ukraine. And certainly I have not seen any trends of that, although there isn't a specific reported decision on the issue in the last 10 years. The trends in the case law do not demonstrate that. It requires more. So as Allison asked, yes, I think it is important for practitioners to tell their clients that it is still worth fighting for, particularly in the country of Canada.
Thank you, Farah. It was really interesting. Thank you very much. Next is UK jurisdiction, and I do know that it will be very interesting, and as there are quite a few cases on return to Ukraine under the convention. This section will be presented by a powerful team of Mrs. Carolina Padrena, a partner of Dawson Cornwell LLP and vice president of International Academy of Family Lawyers, as well as of Mrs. Laura Coyle, a partner of the Freeman Solicitors and co-vice chair of Child Abduction Lawyers Association.
Thank you, Alexander. I'm going to go first, everyone, and I would say it has been very interesting listening to the other speakers from different jurisdictions. I note particular from what Stephen Cullen said about conflict in Northern Ireland being relied upon in the past for an Article 13B defence. I grew up 30 minutes away from Omagh and was 17 in 1998, which is the year of the bomb. So I think that really brings into focus that The Hague has continued to be robust, and also that we're looking at the situations of children on the ground when applications are being made for return to any country, particularly those with conflict. We have the benefit in the jurisdiction of England and Wales of having 3 quite recent cases looking at applications for return to Ukraine. These cases are all at High Court level. So just to clarify, these are decisions which are persuasive on other High Court judges. And I know Carolina is going to talk further on a recent Court of Appeal decision in a 1996 Hague case. which is a binding decision on the lower courts. And in England and Wales, all of our cases start off at High Court level. So since 2022, we have had at least 3 reported cases. Because these cases are reported, they're anonymized as to the particular details. And I'll go on to discuss one in terms of geographical location, where we're not given the precise details of where that return is sought to in Ukraine, only told that it's close to the Hungarian border. But what these cases show is that, yes, Article 13b is being pleaded, and usually by the parent who wishes to keep the child in the UK. But it also brings into focus a number of other aspects, such as arguments on habitual residence, and the first case, which is X and Y, the issue of a return to a third state. Return to a third state is something which English lawyers could probably talk for hours upon, because in the first particular case, what the judge was being asked to consider is whether, following the displacement of a family to Germany, the Hague Convention could be utilised not for a return to Ukraine, but for a return to Germany. And the circumstances in that case was that the mother, children and grandmother had fled Kiev, had gone to Berlin. The children had been sent on to England to stay with their father on the basis that mother would remain with grandmother while she got a visa to come to the UK. It became very obvious very quickly on that she wouldn't get a visa, and therefore the mother requested that the children come back. Father objected in England, issued domestic proceedings after the mother sought advice from a German lawyer, and the mother subsequently issued her Hague application. Now, the circumstances of that case was that the judge wasn't being asked to return the children to Ukraine, and did make some overture comments about how perhaps would have struggled if that was the actual application. But what she did find was that the Hague Convention is capable of being used under Article 12 to have a return to the carer and a state of non-habitual residence, so in this situation, Germany, and also dismiss the consent and acquiescence Article 13a defences advanced by the father on the basis that the mother had only agreed to the temporary relocation of her children on the basis that she and grandmother would also join. The judge did actually find an Article 13b defence under child's objections for the eldest child of the sibling group, which is quite surprising because that eldest child was only 9, but exercised her discretion to return. We then move on to the case of Q&R, which is a September 2022 decision. And that was a case where the mother and child had relocated under the visa resettlement scheme to England in April 2022. Shortly thereafter had spoken to father, who was English and living in England, though separately to mother and child, about the prospect of returning back to Ukraine, as it was becoming very clear that where her family resided, which was close to the Hungarian border, was actually a very safe area. Again, father objected, made an application under domestic English law for prohibited steps in order to prevent the child being removed onward to Ukraine. And the mother subsequently issued her application under the Hague Convention. Father relied on a threefold Article 13b defence. His habitual residence argument was quickly dispensed with, bearing in mind that the child had only been in the UK since April when this matter actually reached the court and Hague proceedings were issued in the July. But the father's three-pronged Hague 13b defence was risk of physical harm because of conflict, and then risk of psychological harm because the lack of functioning courts in Ukraine and their inherent biases towards him would mean that he wouldn't get a fair trial in the event that mother prevented contact. Those were resignedly dismissed by the judge on the basis that Ukraine is, of course, a signatory to both the 1980 and 1996 Hague Convention, and there would be no suggestion that a Ukrainian court would not uphold any application made. But in any event, mother had always promoted and supported contact. The case of Q&R makes it very, very clear, and Mr. Justice Williams, who was the presiding judge, says that we have to look at cases on their specific facts. And he carried out a risk assessment of what life would be like for this particular 5-year-old if he was returned to this particular area of Ukraine. And he concluded that Firstly, it was an area which was relatively safe. It was an area in which infrastructure was still functioning. It was not an area of particularly military interest. And more importantly, mother could be relied upon to safeguard the child, because at a time when she thought there would be a risk of harm to the child, she was able to quickly leave and travel onwards. And so in that circumstance, there was a return ordered to Ukraine. We then come to the most recent reported case, which is from March this year. This is a highly unusual case in that the father who was seeking the return to Kiev had actually conceded The Hague by the time it came to the court. But the Deputy High Court judge took it upon himself to give a judgment dealing with the principle as to whether or not, in a generic sense, so very, very different to Q&R, which makes it clear that we look at case specifics. The case of Z and X looks at whether, in principle, the ongoing conflict in Ukraine is capable of amounting to an Article 13b defence. We aren't giving really much detail about the family situation in this case, save for that the mother and children had left Kiev at the start of the invasion, had travelled to Slovakia, onwards from Slovakia to the UK. And then after a period in the UK, the mother had issued divorce proceedings. So that had led to the breakdown of the relationship, which, as we see, happens often in Hague cases, can really kickstart an application made then for return on the basis that father in Kiev was not anticipating or expecting that the relationship would then no longer subsist. In the circumstances of that case, what we have is a judge looking at contemporaneous media reports, advice from the Foreign and Commonwealth Office, and also from the US government in terms of travel to Ukraine. And he concludes that based on the information before him, that it is capable to mount a successful Article 13b defence in respect of the conflict in Ukraine. That particular judge comments in the judgment that he has decided to set out a judgment, which is a reported case, on the basis that there are other cases which may involve application for return under Ukraine. But we are left in the final paragraphs of that judgment with a return to the position in Q&R, saying that it should be very case specific. And I know Alison and the work that Reunite do in England and Wales, and we definitely do promote and support mediation. And I echo what she says about the importance of the correct legal advice being sent out to parents. And what is clear is that the information needs to be provided to the judges as to what life is like for these children. And we have seen it repeatedly through the cases. I think that everyone has mentioned it involving Israel, that there are circumstances where an overarching portrayal of an area of conflict can be taken as read. But there are children living in lots of countries all around the world who lead perfectly happy, safe lives where there are reports of conflict in particular areas. So I echo what Alison says about the importance being sent out to Ukrainian parents, that all is not lost. And it really is important seeking the benefits of correct and focused legal advice at the start. I haven't had particular experience of a request made for return under The Hague in a Ukrainian case since the start of the conflict. I have dealt with cases prior to the conflict, and in one of the cases that me and Alexander both worked on, where a return was ordered, but luckily my client was able to secure leave to remove to come back to the UK through the Ukrainian courts. I think Carolina will probably address on her own experiences or more recent experience, and in particular that Court of Appeal decision. So I'll hand over to Carolina.
Okay, thank you, Laura. First, I agree with Laura today about everything that she has said. This is not common when we are in court, but today I agree with her. This is the way that we are dealing with these cases in the UK. We are sending the message out that we are applying with the convention with Ukraine. And we are also dealing with cases with Russia, which I have my own reservations, but we also sending the message that we are applying the convention with them. So before I go into the topic, I want to say thank you to the organizers, the Family Law Committee of the IBA, and the Civil and Family Inheritance Committee of the UBA for organizing this event, for putting us together, because we need to send the message out that the Hague Convention 1980 and also the 1996, which is very important in the UK, is applicable with the UK and in Ukraine. So Laura has been talking to you about the most important cases. I was thinking, like, why we have so many cases? The invasion was in February 2022. We are past a year from the invasion. I think it was because we were one of the first countries that dealt with the visa scheme. So I think we attract a lot of families immediately, because we maybe one of the benefits of not being in the EU is that we dealt with the visa scheme immediately, and we welcome a lot of families. Most of the facts of those cases is that the mothers were coming with children, and the fathers they remain in Ukraine because they need to stay over there for the obligations with the country. So we noticed that a lot of the cases is like those children are living here. When they realize that they can go back to Ukraine, things have settled down in the situation, or the family have moved within the Ukraine, then the mother doesn't want to return. So Laura has dealt with most of the cases with Ukraine. 5 of them has been reported, many of them has not been reported. Most of the cases that we are seeing now is children who came with relatives under special guardianship agreements between the family that they were not officially approved in Ukraine. So we are dealing with those cases now where those children are here, and we want to legalize those foster arrangements. So cases, I think the message has been sent out that we are applying the convention, and as Mr. Justice Williams said, is case specific. So I will be talking about a case that we dealt with Mr. Justice Williams resolved, and it was with Russia. And he is quite interesting because he used the same terminology that he used for Ukraine. He said, we need to comply with the convention. We are sending these children back to Russia. So it was a family of 4. 2 of them were retained in the UK when they came for a holiday. This family were meeting in Lithuania because they couldn't travel directly from Russia. So the father retained 2 of the kids here. One of the kids was 12 years old and nearly 13. He was objecting to return to Russia. The father was using the fact that he wrote articles against the invasion as a risk for the children to live in Moscow. And a return order was made, even that the child was considered, and we conceived that it was objecting to return. When the judge exercised discretion, they sent the children back to Russia. What I find interesting professionally is that we continue to use Article 13b when we are referring to the invasion of Ukraine and the situation in Russia. And I agree with when our colleagues from the USA that maybe we should be thinking about Article 20, or when are we touching the angle of Article 20 in this situation? But it's interesting that, again, in this judgment, it was only Article 13 referred to the political situation and the war. So paragraph 87 of the judgment is says, so as things stand and on the evidence before me, whilst I accept that there is a generic risk to any individual who opposes the Putin regime or is a dissident, particularly those who make public that in the news or by attendance at demonstration, there is nothing which identifies a particular risk to these children. So that's why he was making a return order of the children to Moscow. So again, just to remember that Article 13b, the burden of proof is in the parent who has removed or retained the child. So in this case, the court concluded that the father didn't satisfy the court with that, the risk was grave, that it will be placing the children in that kind of situation. So that is the message. I think we continue to apply the convention. We should apply the convention, the 1980. But as I said when I started, for me, the most important one is the 1996, because we have a lot of cases of these children that they need to have a status as to why they are here and what is the relationship with the relative that is looking after them. The most important decision, as Laura has anticipated, is from our court appeal only recently from June. And it was a very interesting one on jurisdiction. So it was a family living in Ukraine. They left immediately in March 2022, mom with the children. They moved initially to Germany. Then from Germany, they heard about the visa scheme in England, and they come to England with that visa having been granted. Father remained in Ukraine. So when they are in England for a few months, they were based in the Midlands. The father arranged some kind of holidays. So two of the eldest children go with the father to Thailand on holidays. And then from Thailand, the father moved them to Ukraine and retained them in Ukraine. This kind of case is the mother applied for an application under the Hague through the Ukrainian Central Authority in Ukraine. But the father made an application first for a leave with order, a custody application in Ukraine, before the mother made any application here. So the issue in this case was which court have jurisdiction about these children, because these children, whether the children were habitual resident in England, whether even if they were habitual resident in England, the Ukrainian courts have jurisdiction because the application has been issued first. So very interesting reading. We can send that to you. We can send you all the cases that we have referred to, Laura and I, in particular these 5. I think they are very interesting reading. But the message from our Lord Justice Moylan, who is the head of our international liaison office, is that he said that despite the judge below's views of the situation in Ukraine, the court still needs to adapt to these conventions. And that is the message from the UK. We need to continue to apply these conventions because we are protecting children. So we need to remember we are dealing with private international law. Let's do the public law with the 2 other individuals. But by international private law, we need to defend these conventions and to apply them. Thank you.
Thank you, Alex. Do you want me to take it from here?
Yes.
Okay.
Please.
All right, unless someone has a question at this point. No, Carolina, thank you so much. Laura and Carolina, thank you so much. Now we are going to turn to our professional from Scotland. Her name is Shonit Cochrane. She's the senior solicitor from SKO Family Law Specialists. She's heavily engaged in legal cases related to Ukraine since the start of the war. And she smiled because I said her name correctly. And I'm very proud of that fact.
I know.
Thank you for joining us, Shonit.
Thank you. Thanks. So it was really interesting to hear the other kind of perspectives from England, Canada, and the US. And I must say a lot of what's been said is similar to what I'll say. So Scotland and England are often considered to be the same, but we are different jurisdictions, we're different legal systems, and we do approach things differently to England in many situations. English case law is not binding on Scotland, but it is something that we sort of find quite persuasive. So the cases that have been mentioned by Laura and Carolina are all quite relevant to what I'm going to say. So in Scotland, we haven't had any reported cases dealing with the specific question of whether it should be return order to Ukraine since the war began. But the sort of general trend of Scottish cases and international abduction kind of do give an idea of what the court would likely do in a case of this type. So the Hague Convention is incorporated into Scotland by the Child Abduction and Custody Act 1985, and our court's approach in dealing with these is by summary proceedings. So it's a much kind of quicker process than a normal case. So there's no oral evidence in these cases, just written statements, and in some cases you don't get the chance for witnesses to respond to each other. And that should make for a quick process, but we have had a number of Hague cases which have taken quite a long time to reach a decision, sometimes over 9 months. So that the court do kind of balance the need for speed with the detailed analysis of each situation. And I think that's even more important when you're dealing with these cases involving Ukraine, because you do need that detailed analysis to work out what the situation actually is, rather than taking any blanket rule for any country or situation. And I think in a similar vein to the English courts, that the Scottish courts will be keen to make it clear that the war in Ukraine doesn't automatically mean that the grave risk exception is established, and that we do take that detailed analysis that's required by the convention. Before I went on to grave risk, I just wanted to kind of briefly mention the habitual residence defence as well, because I do think that's something that might come up in a lot of these cases involving Ukraine. If there's sort of return shortly after a child has been abducted, then the likelihood of habitual residence changing is maybe less, but we have had a couple of cases, one of them ML against JH, where the court decided that the habitual residence of the child changed almost immediately on the wheels of the plane lifting up off the ground to go to the new country. So we can have that shift in habitual residence quite quickly, which would obviously cause problems with the Hague Convention. We've also had quite a number of children living in Scotland since the war began, who've now been at school for over a year, established lots of friends, family maybe living here. And as the time increases, that possibility of habitual residence shifting does change. We've had cases as well, H against W, where it wasn't a Hague abduction case, but they were looking at whether it was in the best interest to return children to Dubai with their father. And the fact that they'd been in the UK, been in Scotland for 4 years was relevant, and that was part of what was taken into account by the courts. Even when there's temporary moves for trial periods or periods that are less than a year, the courts have said that the child's habitual residence could change quite quickly, and that was a case of F against M just in 2021. So we'll see what happens when that comes before a judge in relation to Ukrainian children. And I know it's quite a factual question, so we'll see what happens, and especially given the circumstances and the reasons for the move, that might be relevant. But it is something that I do think is going to come up quite a lot in these cases. So the other main ground, the Article 13b grave risk. So when our courts are assessing grave risk, given the current situation of the war, sort of persistent missile attacks and the like, the defence is most likely to be raised, and there's potential for the courts to say that it's engaged. But our courts have been clear in recent case law that it's a detailed assessment of the particular risk for the particular child and the particular circumstances that's needed. I think I said earlier that there's no blanket approach to sort of particular countries or situations, and we've had a recent case of AD against SD where the court refused return to the US given the lack of effective legal protections. The court weren't willing to make assumptions about the position of a particular country or how an individual situation would be approached, and they looked at the detail of what would actually happen for that child. So we've got lots of cases where they may appeal sort of similar on the face of it, but once the court dig into the detail before they decide on the individual situation of grave risk, they can diverge quite a lot. In the context of Ukraine, what that would mean is that the court are looking at the status of the war, what independence evidence there is available for that, the situation in a particular town or country, the regularity of attacks, how the court systems are working there, whether schools are running, shops are open, and really just assessing the situation on the ground for that child if they were returned. And that likely means that there'll be different outcomes for different regions. So similar to the English case of Q against R, where there was return made there because of the particular circumstances of that town, but when they were discussing return to Kyiv, then there was a different approach made there. And I think that's the sort of position of Scots laws. They're not willing to take things at sort of face value, and they will interrogate the situation to see whether there is a risk rather than making assumptions just because there is a war. To close off that, I suppose that protective measures can also come into play, and our court's really keen to find out what protective measures are available if they're looking at grave risk. Obviously, that's a bit more difficult when it's the war's out with parents' control, but there can be certain things that can be put in place to alleviate the grave risk. And I think that if certain undertakings are given and the like, then that's the kind of thing the court would take into account. One last thing as well that I thought might be worth mentioning is in Scotland we've recently had cases where the courts have looked at children's immigration status when they're ordering return. So where a child is considered a refugee and there's Hague proceedings raised, the Refugee Convention allows for an order to be made, but it can't be implemented whilst the child remains a refugee. So we've had a recent Qatari case in Scotland, which is called A against B, and the child had refugee status in Scotland, and orders were sought for return to her parents in Qatar. So it wasn't a Hague case, but the court did follow an English Hague case of G against G, where they said that the same principle applied, that return could be ordered but not implemented while the child had refugee status. In Scotland, Ukrainians, their status isn't quite the same as refugee status, so there won't be a legal bar to returning under the Hague Convention, but the nature of their visa might be a consideration for the court. And certainly if some Ukrainians have perhaps applied for refugee status, then it's something that would be relevant. So again, just something that might come into play in the court's approach to return orders here. I guess our overall approach in these cases is quite a detailed, granular analysis rather than making assumptions and generalizations. So, the Scottish courts are alive to the terrible situation the war has created for families and how that is constantly evolving. And they're trying to be quite sensitive to dealing with these cases to see where we can assist and support families affected by the war. And those children that aren't returned, we'll still continue to provide them with support here where we can in Scotland. And I guess it's sort of we're taking the same approach as the other states, where we're continuing to apply the convention and continuing to look at the individual circumstance of a child and not taking any blanket approaches. So I think, yeah, that's something that needs to be communicated to families so that they know the position and aren't working on assumptions themselves. So I'll hand back now.
Thank you, Shanish. That was great. We appreciate that. Okay, our next speaker is Manuela from the Manuela Terrini law firm. She specializes in Italian, European, and international family law. She's been practicing in Bologna for 30 years. She's a Supreme Court lawyer qualified to practice before the higher courts. So thank you so much, Manuela.
Thanks to you. Good afternoon. Thank you for inviting me to this event. It's a great pleasure for me to be here. A few words regarding this, what we are talking about today, because in Italy, at the moment, we have no return orders in Ukraine, I mean, during the war. Because let's say that Italy ratifies Hague Convention 1980 in 1994, and in the years the application of Article 13b has been more and more reduced, just like the spirit of the Hague Convention 1980 says. And now we can surely say that the Article 13b is not, yes, is applied, but just like an exception, and war in this case at the juvenile courts, which are competent to decide for incoming child abduction cases. The war is considered as an exceptional event, a grave risk for the child. So you know that in Italy, the orders, the return orders, but in general, the decision of the first and the second grade phase of the trials are not published. So no, only the Supreme Court orders. And at the moment, I have talked to the head of the central authority in Rome, and he told me that he do not remember when I called him any case where has been ordered the return of the child in Ukraine, just because the risk for the child was considered too big. And that's why I have many conversation with the judges of the juvenile courts, because I don't know if you are aware that in Italy, the juvenile courts are not so many. There are only, for example, only one in Lazio and Rome, only two in Lombardia, Milano and Brescia. They are not so many, and the judges are not so many. So I have because I have been dealing with Hague international cases for many years. So I have talked a lot about those cases with many judges, and they said that of course, it must be each case is a case that must be decided considering all the situation, because there are some places in Ukraine that are not too dangerous, but in general, just like the guide to good practice says, the guide to good practice published by the Hague Conference on Private International Law, war can be considered a grave risk for the child. So probably, I really don't know. Now I have checked the database of the central authority in Rome, and at the end updated to December 2022, and at December 2022, there were 11 outcoming cases with Ukraine, 13 cases, ingoing cases, but we have no. I have no. I think that there are no return order to the Ukraine, to Ukraine. I don't know if in some cases, just like I hope, because I really believe that what Alison said before is really correct. So I hope that some cases have been closed because of mediation, thanks to mediation, but I really don't know, because the cases are not published, and we know only when they are closed and when they finishes. I have dealt with many cases, but no cases with Ukraine at the moment. So in my opinion, as far as I know, some cases are still pending because the order is not going to be issued, the return order, and the other are trying to find an agreement between the parties through the mediation. Because I know the juvenile courts in Italy and the war in Ukraine and what's happening there, it's a grave risk for the children. So that's the opinion of the judge, of course. So this is what I can give you as my overview for all the relation regarding the child abduction cases between Italy and Ukraine. Because I think that Italy, in all these years, in 25 years since the Hague Convention 1980 was applied in Italy, I think that Italy has now is applying well the Hague Convention. But there are still some things that are very difficult to make understand to the judges, particularly regarding this case, just like domestic abuse or something like that. There are some things that Italy, even if I agree just with what Carolina said regarding that, of course, we must consider that the Hague Convention is a protection for the children. So it is true that the judges say that we must consider it case by case, there is not in Italy, you know that we have not only one law. There are different courts and different orders and different opinions. But in general, the return order regarding Ukraine is generally denied.
Okay, thank you, Manuela, very much for your insight into Italian jurisdiction. It was really valuable and interesting, and I'm sure that more cases, let's say, to come. So let us expect some new case law in Italy in this regard.
We have, sorry, just a few words. We have many Ukrainian people in Italy, many, but they are a part of our population, not child abduction cases.
Yes, thank you.
Okay.
And our next speaker is Mrs. Corinne Suzanne Delerue, our fellow colleague from Germany, who represents this jurisdiction today. It appears that Germany kindly provided a shelter to the largest group of Ukrainian nationals as of now, and therefore we may expect the presence of some relevant case law in the local courts. Thus, I'm passing the word to Corinne, please.
Okay, not my first Zoom meeting. Hello, everyone, and thank you for the nice invitation from the Family Law Committee of the IBA and the Civil Family and Inheritance Committee of the UBA. It is very nice to talk to all of you because actually, Alexander, I was verifying the numbers before when I was preparing my part here, and I actually do know Joanna very well, and I know her from the cross-border situation that we, of course, had. Germany received by now more than 1 million refugees that are registered, and Poland is just below, so it's just 100,000 difference. This is a situation that astonished me because I only found 3 High Court decisions to prepare for this meeting, and I think I can show the arguments of the German jurisdiction very well on a decision of the High Court of Stuttgart that was already published on October 13th in 2022. So what we have in Germany is we have a very short proceeding time for the Hague Convention. That means that family court is obliged to fix an audience within a delay of 6 weeks, and appeal court as well. So what we have in the situation is that we had married parents living together with their daughter born in 2021 in Odessa. During the bombing alerts, they spent the nights in the parking garage under their building. On March 2nd, the mother decides without the father's consent to leave Ukraine with their child and spend the next time in Germany. It was not declared by the time to be a move in the meaning of not returning at all. On July 27th, the father filed an application based on wrongful removal of their child and asked to order the return of the child. He also ensured to have rented 2 apartments for mother and child and himself, and could provide support for both of them, because that is very important. If you file for a return order in Germany, you have to provide it. The child was only born in 2021, so it was a small child, and he could not estimate that the court would return only the child's return. So he had to provide support for the mother as well, what he did. So he did everything perfectly by the Hague application, the Hague Convention in Germany. So the application was filed in July, and the court already fixed an audition on August 26th. It had immediately named a guardian ad litem. So this is a lawyer for the protection of children's role in proceedings in Germany, and had auditioned the father and his Ukrainian lawyer via WebEx, because of course the father and the lawyer, both male, could not exit Ukrainian territory due to the war. On August 30th, family court rejected the return application and argued in an absolutely clear way that the mother had, as a matter of fact, wrongfully removed the child from Ukraine because there was no doubt in the habitual residence of the child in Ukraine, and the father had never consented the relocation to Germany. But, of course, then court applied Article 13b, which is rather raw in Germany and has not been applied during COVID. So Article 13b was not a reason to not return a child if in the country of Italy, for example, was the very, very severe COVID situation. But in this case, the German family court declared that there would be a serious danger for the child's health, either in physical or psychological way. The father received the decision in September 6th and filed in the great delay appeal within the delay on September 14th. He added an auxiliary request of returning the child to the Republic of Moldavia. So if not to Ukraine, then to Moldavia, because Moldavia would be secure in his eyes. The then competent High Court investigated the situation again and came to the same results. What is very impressive, that is the High Court's research, because it is a still very concerned statement declaring that the child has undoubtedly been wrongfully removed, but on the own research of the High Court, they decided that the return was nevertheless too dangerous for the child. They did not only consult the travel alerts of the foreign ministry, but they also consulted different and several other sources on the precise region. So in the decision, you have the citation of bombing alerts on the region of Odessa. You have precise and detailed prescriptions of the war situation ongoing in the region the father demanded to get the child returned on. So in Germany, the court has the right to investigate itself, and it's not only a question of evidence you bring to court, but usually they do that on their own. So they refused return to Ukraine, to the region of Odessa, because they declared that it had been a too imminent harm for the child. Then, as they refused the principal request, they had to decide upon the auxiliary request to return to the child to Moldavia. But as neither Article 12 could be applicable because the caretaker didn't live in the Republic of Moldavia, and there has never been a habitual residence in Moldavia, they rejected that as well. So that was the first case. The second case is from another High Court from April 23. And we have two older children then brought to Germany as well on March 3rd, so approximately at the same time. But those children were already ongoing subjects to ongoing custody proceedings in Ukraine. So it was very clear that there was no consent of bringing them to Germany. And in the same way as the other High Court, the family court decided that there would not be a return. The arguing was very precise in the same time from the family court and the appeal court, declaring that children can live in war zones, so that this is not a a white sheet. So you cannot only declare a country a war zone and then refuse returning the children. But they estimated the precise region in Ukraine actually too dangerous in present times, and so they refused the return. There had been in High Court an auxiliary request of the father to order the return within 1 month after the ending of the war, and that was very interesting as well, because actually the father had missed the appeal delays. So usually, if a delay has been missed, the High Court just rejects the appeal. But then they considered this case so important that they argued as well. So they told they in the decision you can find the reasoning that even if he had respected the delays, they would have rejected his request because of the danger, the imminent danger, and they did the same research as the other High Court did. So even if they weren't competent anymore, they decided, they showed in a very large way how deep the research of the family court has to go to apply Article 13b. And they decided that you cannot order a later return because the Hague Convention is to be applied very fast, and it has to issue the orders immediately to re-establish the situation for the child. So you cannot order a later return, not only because it is very difficult to estimate when one will consider a war ended, but that the goal of the Hague Convention is the immediate return. So this was the second decision. And then we had a third case that was quite different, because there was a return request of a Polish father because the mother had removed their daughter from Poland due to the war in Ukraine. So she said that living in Poland was too dangerous because there would be an imminent risk of the Russians attacking Poland as well. So this request was followed. So the return was ordered because actually living in Poland does not bear a danger of imminent harm for the child. And so the application of Article 13b was refused. So what we can say in Germany is obviously that the return to Ukraine will be refused by court, and that so for the parent living in the Ukraine, mediation is the only option to negotiate, for example, a return to Moldavia or in another region close to the coming back. That's it, unfortunately, I think, for the remaining parent. Thank you very much.
Yes, Corinne, thank you very much. It was very interesting, and it was very important for us to know that there are already existing case law, and this case law is rather definite in how German courts consider the ongoing war hostilities on the Ukrainian territory. We have a question from our Cassation Civil Court Judge, Mrs. Stupak, and she's asking the following: what were the motives of the German court when it recognized the relocation as illegal?
Because in the beginning, it was clear that in both cases, the father had not consented the move to Germany. So in the first situation, the mother quitted Ukraine secretly. So she didn't even tell the father. She was just like leaving in the morning and she didn't come back. So the father filed rather immediately the return request. And for the second, it was clear that there was no consent because they were already having custody issues in Ukraine. So there was an ongoing custody proceeding, though the father would never have consented letting the children leave with the mother. Is that responding to the question?
Yes, thank you. I guess yes. I guess yes. So in my opinion, the motives are clear, and if Mrs. Tupak would have any additional questions, so she would write additionally, and I think that after the presentation of the last speaker, we can continue with this if necessary. Okay. So, thank you very much. And last but not least, one of our closest allies, fervent supporters, and definitely best neighbor, Poland. It was Poland who embraced hundreds of thousands of Ukrainians from the very beginning of the invasion, providing them with a shelter and hope. Today, Poland will be represented by Joanna Solek, advocate and fellow of International Academy of Family Lawyers. Please, Joanna, the word is yours.
Hello, everyone. I will try to be short because I know we are far behind the schedule. I am very happy to speak on this panel because I believe that we have in Poland a very particular perspective on the issue. And this is because of the numbers. From the beginning of the war, there is more than 12 million of Ukrainians who crossed the border. Some of them stayed in Poland shortly and then moved somewhere else. Many of them stayed, and a huge number of them returned to Ukraine. So right now we have like 1.5 million refugees in Poland. Counting also Ukrainians who are not refugees in the sense that they arrived to Poland before the war, but they decided to stay because they don't want to return because of the war. So even though not coming to the Poland because of the war, now many of them are staying because of the war. What does it mean in practical terms? I think that Polish people being so close to Ukrainian have a very good understanding on the situation on the ground and of the geography of the Ukraine. So I think that our sense of the danger is a little bit different because we don't learn it only from TV, but very often on the personal basis. I would say that Polish judges have been extremely active in hosting Ukrainian families. So many of them has a personal experience of living under the same roof with Ukrainian families coming from different regions. So for this reason, they have a very good sense of what is the situation in Ukraine. So that was the first remark. I think that we deal mostly with cases of the wrongful retention of the child, not of the abduction. And this is because most of the people who came to Poland have been coming with, let's say, acceptance of the other parent. In some cases, this is not obvious because the law in Ukraine was that you needed to have the written permission to cross the border. And that changed because of the war. So there have been situations when the woman didn't have the permission to leave the country before the war, even though she wanted. When the war started, she didn't need to have this permission. And in these cases, you can argue that having no contact with the father, even though there was no permission, order was case by case to be decided. If we speak about the wrongful retention, then the tricky problem we are facing is to determine the moment from which you can speak about this retention if we assume that the first movement to cross the border had some kind of acceptance, written or oral, or even implied because of the situation in Ukraine. Another remark is the understanding of the habitual residence. I think in Poland, because of the fact that so many people return, now the law is such that they have choice between two kinds of status. If they don't register, they are staying in Poland based on this temporary protection, which does not require any legal work to legalize the stay. And this stay is by definition temporary, which means that I think you cannot speak about the child getting too used to be in Poland, because by definition this is temporary. And the best proof of this is that there is a huge number of Ukrainian children who have been still attending online school in Ukraine, which means that the intention of the parent was to come back to Ukraine and to continue the education in the origin country. And then in some moment it changes, so the mother makes the decision to stay in Poland and not to return. And that's when we have problems. Another way to legalize the status in Poland right now is to apply for the temporary residence. And this is a step further because you are applying for a longer period. You are saying that you are in Poland not because of the war, but for different reasons, such as work, education, and so on. And in my opinion, if the mother decides to apply for this kind of legal residence, then the presumption is that her stay in Poland is not temporary, but the long term. And from this moment, you can argue that the decision is to stay longer and not to stay only until the war is finished. I am a huge fan of mediation. And even though I said in the very beginning that the Polish judges are very sensible to the situation in Ukraine, and for this reason, I don't think that they would make the decision just based on the fact that Ukraine is war, but the decision will be very much nuanced depending on the region and also on the situation of the father. Because from my experience, we have two kinds of left behind fathers. The one who are not active in military, which means that they are living in a safe part of Ukraine and they are continuing the normal life they used to have before the war. And they can provide for the family and the child this normal environment in a safe part of Ukraine. But you have also fathers who have been mobilized and who are either in the active duty or, let's say, in the disposition of the army being very active, which means that they cannot provide for the child the safe environment because they are in the very imminent risk of being killed themselves. And I would say that those kind of parents who are active military, they have a very difficult task to convince the court that they can provide the safe environment for the child, being themselves in war. So this is another aspect. And finishing with mediation, I think that the huge bargain that the mother can do, trying to convince the father to accept the temporary long-term stay outside of Ukraine, is visitation. Because my experience is that the 90% of fathers cannot leave Ukraine, which means that if the child is in Poland, doesn't matter with the agreement of the father or without, father is technically separated from the direct contact with the child because cannot travel to visit it. So the only way to preserve this close relation between child and the father is if the mother agrees to go back to Ukraine for the short time of vacation, whatever, but to keep this relation alive. And well, in my opinion, this is the place for mediation, where we have the acceptance of the father to stay and the acceptance of the mother to send child or go with the child to Ukraine to spend holidays, vacation, weekends, whatsoever, but to allow this direct contact. We do not have in Poland an official registry of all the decisions, so I cannot give you the numbers, how many return decisions have been given, but my guess is that the decisions will be taken very much case by case. So we don't have the attitude that you cannot return the child to Ukraine just because of the war, but we have the very reluctant position of returning children anyway. So my guess is that in many cases, the request for return will be denied just because of many other aspects, not only the war being the pretext to motivate the decision. Thank you very much.
Yes, thank you, Joanna. Thank you very much for your presentation. We actually had long ago a question, and I would read it, and Stephen has already kindly agreed to address this question. So the question is, what if a child from Ukraine is living with mother in a country which grants temporary refugee status under its domestic law? Could an argument not be made that if father claims return of the child, court should not grant permission to return by virtue of refugee law principles, notably the non-refoulement principle? Certain refugees from UA are living under quasi-automatic protection states, no matter which part of Ukraine they come from. So, Stephen, are you ready to address this question?
Thanks, Alexander. Thanks very much.
Yeah, thank you.
Give the American position on this, because it's the opposite of the English position in their case, G and G. In America, the Hague will trump any immigration, asylum, temporary status, temporary emergency status claim. We put the Hague above any immigration claims in this country.
Maybe someone else wishes to briefly address this particular question.
Well, in Poland, we differentiate between this temporary protection that is given to Ukrainians automatically and the asylum status. So I would say that a huge majority of them is not applying for the asylum because there is no reason and there is a huge legal differences. And just this temporary protection, in my opinion, because of those differences, doesn't qualify as any kind of excuse for refusing the return status.
Great, thank you very much. Thank you, Stephen and Joanna. I remember that Alice has some questions.
Oh, wait, did Farah want to say something? Farah, did you want to respond?
So I was just going to say that in Canada, it's treated a little bit differently. It gives rise, like there's a specific case on point called AMRI versus KER, and it gives rise to a rebuttable presumption that the return of the refugee child gives rise to risk of persecution. But so it just basically heightens the threshold in the exceptions, but it's not, the Hague is not treated as a trump card in Canada. It's more, it gives rise to this rebuttable presumption that you have to go into. So.
Shanich, I see you.
Yeah, I've mentioned that we had a case where this question did come up, and the court said that they could order return, but the return wouldn't actually be implemented given the refugee status, and that was based on the English case of G against G, which Stephen mentioned. So I mean, Laura and Carolina can perhaps confirm, but I think that we've got kind of a similar approach, that if you've got refugee status, that would be a legal bar to return under Hague.
So Alex, I'd rather defer to anybody else who has questions because we have run over so far. So if there's anyone who's attending that has questions, or even any of the panelists who have questions for the other panelists, now that you've heard each other.
Yeah, definitely. So we are waiting, and I think that we will be able to address one more question, and then we will say goodbye to all of our honorable speakers and our audience. So.
Олександре, там є одне питання до мене по строку. Я можу відповісти?
Так, звичайно, будь ласка.
Так, питання адресоване мені, але я думаю, що всі зможуть на нього відповісти. Як практика має справлятись з обмеженнями в 1 рік при поверненні в Україну дітей в післявоєнний час? Питання дуже цікаве. Перше, з чого я б хотіла почати свою відповідь, це з того, що національні суди, ну, принаймні Верховний суд так орієнтує національні суди про те, що оцей рік потрібно рахувати з моменту незаконного переміщення і оцінювати початок процедури в країні перебування дитини. Тобто так, як передбачає стаття 12 конвенції. Саме в країні перебування. Немає значення, чи в суді ініціювання процедури, чи в компетентному органі. Мається на увазі подання заяви відповідної. Я чому цікавилась мотивами рішення німецького суду, оскільки суд оцінив оце переміщення після початку війни як незаконне, так, я зрозуміла, в зв'язку з відсутністю згоди батька на виїзд дітей навіть після початку війни. І в цьому плані, якраз в питанні розрахунку і обрахунку строку, важливим буде оцінка суду конкретних обставин, коли вважати настав момент незаконного переміщення чи незаконного утримання в Україні. Бо ми розуміємо, що може бути ситуація, коли батько, наприклад, погоджувався, щоб мама виїхала з дитиною після початку війни, але, дай Бог, от війна скоро закінчиться, і мама не бажає повертатись. Це одна ситуація. І ситуація та, яку розглядав німецький суд, де з самого початку не було згоди батька на виїзд дітей. І суд це оцінив як незаконне переміщення. Тому в цьому контексті важливими будуть обставини кожної конкретної справи. Чи то було незаконне переміщення, чи почався період незаконного утримання дитини, хоча на момент переміщення згода була батька, наприклад, чи письмова, чи мовчазна, саме в зв'язку з подіями в Україні, в зв'язку з війною. От така моя відповідь, тому я думаю, що тут одразу такого конкретно не можна сказати, все буде залежати від обставин конкретної справи. І дуже дякую, колеги, я почула майже відповідь на всі свої питання і зрозуміла один важливий аспект, хочу його так би підсумовуючи озвучити, в питанні застосування підстав для відмови в поверненні, як то пункт Б, наявність істотного ризику для дитини. Я так більшість схильні до того, що потрібно оцінювати конкретний регіон і конкретну ситуацію, ну, будемо говорити, в тому місці, куди просять повернути дитину. Тобто нам є над чим українським суддям подумати в цьому питанні. Дуже дякую.
Так, дякуємо теж, Ольга Вячеславівна. So, the question was as follows. How do you think the legal doctrine and case law would deal with those so-called limitations applied by Article 12, I mean 1-year term, when dealing with the cases of returning kids to Ukraine after the war. So maybe someone has something to say, like very briefly. Or should I translate it once?
Can you just read it one more time?
Yes. So, what do you think? How the courts will treat this 1-year limitation term? I mean, most likely all the return requests would be filed when this 1-year term applied by Article 12 would expire. So how courts would treat this when there might be a lot of such return cases after the war would end?
If you want, Alex, I can address it from England.
Yeah.
So after 1 year, it will be, I think here it will be habitual residence and settlement. So whether those children has become habitual resident in the country of refuge, or in the country where they moved to. So it would be an examination of facts. So they could have become habitual resident 1 week after, like our Scottish colleague said, like once they take the plane, or maybe they took them a bit longer when they are teenagers, they have strong links with friends still in Ukraine. So it will be an examination of facts. Then it will be the 1 year, even if they are settled, because the year has passed, the court can still exercise discretion as to whether it is in the best interest to be sent back to Ukraine. So I think that is the way that I see it, the way that it will be dealt with in our country.
Okay. Okay. Thank you very much. Thank you very much, Paulina.
Stephen, did you want to say something?
We have returned lots of children to what Americans might consider very, very poverty-stricken places. And our jurisprudence has said that you can't consider any of that. So I don't see how post the war anyone would succeed easily on a claim that we're returning children to a post-war landscape. I think that would be very unlikely.
What about the 1 year?
So the 1 year, we have a Supreme Court case called Lozano about the 1 year. And we thought until this Lozano case that you could toll the 1 year because of certain situations. The Supreme Court says you can't toll it, but you have to take everything into consideration. And it is a discretionary 1 year, not an absolute 1 year.
Thank you. And Karen knows how to use her virtual hand, and so does Maria. You guys are good. I always look for the virtual hand going, where is that thing? Okay, I'm going to go Karen.
I found it finally.
You're impressive, Karen. I can't even unmute, so you're just way beyond me. Go ahead.
Thank you very much. So actually, I have doubts that the 1 year delay will be extended very much. So I think the Hague Convention doesn't allow what we would call in German jurisdiction analogies, or the necessity of prolonging a delay that has been fixed. So a delay is a delay, and the Hague Convention and the return proceedings are a very specific way and a very specific proceeding. So I don't think that this would be the case, but we would examine, as Carolina already said, the facts, and in the custody hearing, I think the wrongful removal to Germany would be considered a fact that could eventually change the decision of the court if the children have not been integrated into society and surroundings the way it's at least it's the child's benefit that should be the perspective, and the argument that not returning a child to a war zone or a post-war zone, I think that wouldn't be followed, but the integration of the child would be very pertinent. So I'm muting me.
Representative Snitsko.
Yes, thank you. I would like just a small remark. We also discussed this issue with the Hague Conference, with the Parent Bureau of the Hague Conference in particular, with the colleagues, with another central authority. But the main idea was that the temporary protection has this temporary character, and all the families and people are supposed to return after the end of this temporary protection period. But of course, when we're talking about the application of the Hague Conference, this is the crucial issue. Because 1 year period of time has elapsed completely in all cases. So I agree with the colleagues who talk about the decision of the court on the case-by-case basis. It could not be the only possible solution, the only possible variant for all the cases. So this is the main idea, and a small remark that when we are talking about refugees, of course, this is the one issue, and the protection, temporary protection, which is granted in EU, is a little bit another case, and we consider that the application of this protection of the refugees cannot be applicable for the children and families which travel to EU after the starting of war, and actually which are under the protection. From our point of view, these are two different categories of children and of the ways of protection. So, thank you. This was my remark. Thank you.
Yeah, let it be. It's very nice to see it. So I guess that's all for today. I'm very grateful to all speakers.
Alex, I don't mean to interrupt, but I think Joanna wanted to say something briefly.
Yes, of course.
Just very short comment. Looking on numbers, my guess is most of the people left just when the war started and until the summer of last year. So actually 1 year is over for most of the families. And my guess is that the huge wave of the cases we will see is when the war will be finished. And the people will argue that we are dealing with the wrongful detention because there was the permission to stay as long as the war is on. The war finished, temporary protection finished. Expectation of the fathers is that the children and the wives were going back home. And that's the moment where I expect the rise of the cases based on the Hague Convention.
Yeah, definitely. And I think that it is also one of the reasons why should we organize and meet once again in a while. So I guess finally, that's all for today. Thank you very much to everybody, to speakers, to participants who stay with us until the very end. So I think that we had a lot of interesting and very valuable presentations today. Therefore, I guess we would have to meet in a while and discuss these issues once again when we would have a bit of more new case law in this regard. So, Alice, I pass the word to you.
Thank you, Alex. Thank you. You know, the IBA continues to work with the Ukrainian Bar Association and members of the Ukrainian legal community, support them, the Ukrainian people, and the rule of law. The Family Law Committee is going to be leading a session at the IBA's annual conference, which is in Paris this year, October 29th through November 3rd. And this session's on November 1st. It's called Children, the Innocent Victims of War and Other Disasters. We will be talking about not just the abductions, I shouldn't say just, but not only abduction, but all the other things that happen to children when they are living through disasters such as war, because we all know that they are our future and they suffer. So if you can make it, we'd love to have you. I do want to thank specifically not only all of our panelists, but Judge Stupak and Representative Snitchko and Alex and Victoria. You worked so hard on this under conditions that the rest of us didn't have to work under. And we thank you so much for that. I used to live in Moldova 20 years ago and worked there. And I have to say, I came to know your culture and your country. It's beautiful. And you are a credit to it and your profession. And I thank you very much for all the work that you've done today for this conference. And I'm going to just leave you with a quote from Nelson Mandela. History will judge us by the difference we make in the everyday lives of children. Alex, Victoria, thank you.
Thank you very much, Alice. And finally, I wish to thank, of course, to IBA, to UBA, and to our two brilliant translators who assisted us.
That's right. That's right. They were fabulous, fabulous. Thank you so much.
So thank you. Bye-bye, everybody.
Bye-bye.